If vicarious liability has been confusing you, here's the simplest explanation you hear today. Vicarious liability simply means one person is being held liable for the wrongful acts of another. In tort law, this usually means an employer is being held liable for a tort committed by an employee, even though the employer himself did no wrong. So we are not asking if the tort was actually committed. We are asking if the employer should be held liable. And to answer this question, the court asked two main questions. First, was the person actually an employee? Second, was the employee acting in the course of their employment? Let's answer the first one. Is the person really an employee? Not everyone who works for you is your employee. Some people are independent contractors, and generally, you are not vicariously liable for their thoughts. So, how do the courts tell the difference? They use a number of tests. First, the control test. It answers a simple question: who controls how work is done, what work is done, and where the work is done? If the employer tells the person what to do, how to do it, and when to do it, then that person can be called an employer. But this test became less useful as professions specialized. For example, a hospital employs surgeons, but can the hospital tell the surgeon how an operation should be done? Not really, right? That led to the integration test, also called the organization test. So instead of asking who controls the work, we are now asking, is the worker part of the organization, or are they simply providing services to it? If the worker is woven into the business itself, then they are more likely to be an employee. So we have to determine if the person is in a contract of service or contract for service. Now, in contract of service, we are asking if the employee is employed as part of the business. Whatever they are doing, is it integrated into the business? Does it form an essential part of the business? And contract for service, we are saying that what the person is doing is not exactly integrated into the business, but only an accessory to it. This was established in Stevenson versus MacDonald, where they said if a person is acting for a business in his own account, then he is not an employee. You can also look at the case of Ready Mixed Concrete versus Minister of Pensions. So, how do the courts determine who is vicariously liable? Again, they ask some questions. Number one, was the employee doing something not authorized by the employer? Not authorized. If yes, then the employer is not liable. Number two, was the employee doing something authorized by the master but in a wrongful or careless way? If yes, the master is still liable. Mhm. That is exactly what happened in Century Insurance versus Northern Ireland Road Transport Board. In this case, a petrol tanker driver was delivering petrol when he lit a cigarette in the course of the delivery and caused an explosion. Guess what? The employer was still held liable because the employee was doing exactly what he was employed to do. Even though he lit the cigarette, which wasn't part of the employment, he was doing his job. He was delivering petrol. But what if the employee departs from their work? That is where you need to distinguish between a detour and a frolic of one's own. So a detour is a slight deviation from one's work, whilst a frolic of one's own is a total deviation from one's work to pursue a personal mission. This was established in the case of Storey versus Ashton. So, for example, you work for a delivery company and you were sent to deliver a package. Now, after you left the company, you branched to go and visit your girlfriend. If you're going to visit your girlfriend and then you get an accident, your employer may not be held liable. Even if after seeing your girlfriend, you are returning to deliver that package and an accident happens, your employer may not be liable or will usually not be liable for that act. This was further explained in Rayner versus Michelle and also Joel versus Morrison. Now let's get something. An employee does not automatically leave the course of employment simply because they disobeyed instructions. In the case of Rose versus Plenty, a milkman disobeyed his employer's instructions and asked a young boy to help him deliver milk. The young boy got injured. The employer was held liable because the milkman was still carrying out his duty, delivering milk. So, breaking instructions does not necessarily take the employee outside the course of employment. Modern courts also apply what is known as the close connection test. This asks whether the wrongful act was closely connected to the work that the employee was asked to do. If it was, the employer may still be liable. You can look at the case of Lister versus Hesley Hall Limited. Now, here are a few things I want to add. If there is a case of vicarious liability, both the employee and the employer are sued as joint tortfeasors. An employer would not be held liable where an employee uses the employer's property for his own purpose, even if he had the permission of the employer. An employer who expressly prohibits an act may still be held liable if these prohibitions are within the scope of employment. You can look at the case of Canadian Pacific Railway Company versus Lockhart. So if you see a vicarious liability question, ask yourself if there is an employee-employer relationship. If you're in doubt, think of the control test, the entrepreneurial test, the integration or the organization test, and also ask if this wrongful act was done in the course of employment. If yes, the employer may be vicariously liable.